Today we're going to be sharing with you a little trick that not many people know about that may very well help you when going through property settlement if you are financially struggling. Welcome, Mark.
Hello, Laura. Hello, everyone.
Now, I was just reading out this little blurb and Mum's like, stop, Laura, that's not you. So I have redone it in my own speak. And today we are going to be talking about something that helped me and I hope could help many people out there. Because there's a thing called early distribution of funds, and we're going to get all the juicy information out of Mum's brain in a moment. But first we're going to go to our jingle. But before we do, a reminder that this may discuss some parts of family violence, financial abuse. If you are triggered by that, please call 13 11 14 Lifeline, or of course, call 1-800-RESPECT if you are experiencing any family violence. Let's get to the jingle.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
So, when I was going through this, and a lot of people go through this, their property settlement may take years.
It can.
If you're lucky, it could take a couple of weeks, but it can take years. And I hear about all these people who are stuck, separated under one roof because they can't afford to do anything because everything's stuck in something. And so today I thought, let's get this message out there. And even if it gets out to even one person, to know that they can do this, to raise it with their lawyer or to go themselves to try, it can make a difference. So, Mum, what is an early distribution of funds?
Okay. An early distribution of funds simply means that you get some money out of your own joint monies to help you do stuff while you're waiting for the final hearing. So it's if there's money in the bank that's frozen, it's about getting some of that money so that you can get on with your life while you're waiting for the final hearing. It's an advance on your share of the property pool.
And does it happen often, or is it a rare thing?
I wish it happened a lot more often, because there are people that I'm talking to who seem not to know that you can ask for money to be released, because it must be just the most rubbish feeling to be struggling to pay the rent or stuck under one roof, knowing there's money in the bank and it's locked up. And I wish more lawyers would tell their clients, and you, dear listeners, you can tell your lawyers that you want an interim property distribution. It might be to pay your legal fees, or it might be just for living expenses, or it might be to get into a new apartment, or it might be, as one lady I was talking to, it bought her whole house. She got enough to buy a house. I think the court is happy to do that if they know that it's going to come out of your share.
All right, before we get into the scenarios when people might need it, can we just check? So an early distribution of funds, it means there's the property pool and there's money in it.
Yep.
And then so you get given a bit of that money, and then on your side of the ledger, when you do have final property, that part's already been given to you, or is it completely separate?
No, it's already been given to you. So it goes back in as property. And then if you've taken some, usually the other person gets some as well, just to make it easy to negotiate, then it is counted as an advance on your ultimate share of the property, except if you've had to use it for reasonable living expenses. But if you've used it for legal fees, or I don't know, to have a holiday or whatever, that it goes in on your side. So when you get it, you need to know that's going to come off what you ultimately get at the end.
So we hear of these people, these poor people,
Yeah.
who are pulling their hair out. They're stuck. Property settlements dragging on. Maybe they've had 3 mediations. This is one example that I can think of that, the only asset they have in their control is the house, but they can't sell it because they're living in it. But there's all this money, like copious, because let's do 2 spectrums. There's the really, really rich, wealthy couple, and there's so much money in shares or somewhere. And those people, it should be only fair that they should
Yeah.
be able to have some of that to live on until
Yeah.
they get to final property settlement.
Hmm.
And we have heard, Mum, of some people saying, "Oh no, I can't sell the shares. There's some reason why, or I
Yeah,
can't do
yeah,
this or
yeah,
some."
yeah.
But that's not the case. That these people, the really extremely wealthy people, like if it's sitting there, it's floating around, then fair's fair, right?
It is. But the point that you made, I think, is this. There's all of this money these people have, all of these shares, but we've got one person who's desperate. One of that couple is desperate, and clearly the other person is blocking access to money. And that's a very common scenario, isn't it, Laura? We see it a lot. And so what you're getting is financial abuse.
And I think that's definitely a reason why some people may need to ask for early distribution of funds. It isn't something you can ask, and we're going to talk about the other end of the spectrum, the really not well-off people that are struggling. Well, actually, let's talk about that first. So
Okay.
what about the other side? They're living under one roof because they've got nowhere else to go. There's only the money in the house. Maybe there's a little bit in the bank. Can they get an early distribution of funds?
If they can identify some money, they can. If the other person is earning more money than they are, and they can't support themselves, maybe they can go for spousal maintenance, which is a payment a bit like child support that comes to you every week or every month. But there really usually needs to be somewhere that the court can go, oh, look, let's just split that money up. So sometimes people in that position where it's the house, what might be holding that up is the other person who's under the one roof with you from whom you want to separate, may be dragging the chain on putting that house on the market, and then once it goes on the market and once it becomes unconditional, then you know your money's coming. And it's ludicrous if it then gets locked up until property settlement. So you can bring an application to the court about that. But I think you're going to touch on an interesting point.
Yes. And so I think it's good that you brought that up. That so if anybody's listening and they're struggling financially and their house money is sitting in someone's trust somewhere, consider asking your lawyer to ask for an early distribution of funds. Go and ask your lawyer, but that is an option. Now, the interesting point that you've raised there, Mum, is the coercive control financial abuse aspect.
Yes.
Which I think is something that will be more and more recognised as we move forwards, as we know the changes are coming June 10th, and there have already been changes last year where they've changed the definition of family violence. I'm just going to quickly read it to you.
Oh, good.
So the bit that I think really, so it's the Family Law Act, Section 4A, definition of family violence, 4AB, and they talk about all the things that you would normally hear that sounds like family violence, but H, is unreasonably withholding financial support needed to meet the reasonable living expenses of a family member or his or her child at the time when the family member is entirely or predominantly dependent on the person for financial support.
Yep.
So, Mum, the reason you're pretty happy about this situation is because why?
Well, because that's quite new. And if you ask for an early distribution, if you ask for, let's say there's $300,000 in a trust account, and that's all the money that you guys have got, right? And you ask for $100,000 as an early distribution of funds, and they say no, then they actually are committing family violence. And after June the 10th of 2025, the court will look at that to see if their behaviour made your contribution harder and whether you should get a greater share of the property pool as a result. So you might have been entitled to, let's imagine it 50-50. You might have been entitled to $150,000. You've asked for $100,000. They've said no to giving you anything. Then you go to court. And the judge says, well, because of the behaviour of that person withholding funds from you, we'll give you an extra 10% of the property pool, an extra $30,000. So you get $180,000, something like that. That's how it does. But Rosie, if you're negotiating, this is the important thing. So don't think if you write and ask and they say no, that you've got them cold. You really need to be able to say to them, look, in our imaginary situation, there's 300,000 in the bank. I propose that I get 100,000 for my legal fees and your client can have 100,000 too, because that's how it normally happens. If you ask for 20,000 for a client, invariably the other party will ask for 20,000. And even if they're earning a big salary and even if they don't need it, if it's within what they might expect to get as a property pool distribution, why not?
So what you're saying is, in the old days, people had
Yeah.
to go to court to ask for an early distribution of funds, and they still do. But
Yes.
because of this new definition of family violence, if you are negotiating and you ask their lawyer or you ask in mediation or you ask in a letter, hey, I'm struggling to pay the mortgage or the kids' stuff, or
Yep.
I'm struggling to pay for food, can I please have an early distribution of the funds? And they say no, and they've got no real good reason.
Mm-hmm.
Their lawyer is probably going to say, guys, you kind of need to say yes, because otherwise you're going to be done for this family violence
Yes.
definition.
That's pretty good. That's pretty good, Laura. That's how things happen. But the point I want to make is if you can offer at the same time as you ask for it, say, I propose that your client would also get an equal amount. So as long as it's not going to be more than their ultimate share, because there's no skin off your nose either way, is it?
No. All right. So reasons why people may want to ask Mum is to pay the mortgage,
Yep.
to pay living expenses, school
Yep.
fees, legal fees, medical fees, anything.
Get a new
really.
car, buy a
Okay.
house, just
Okay.
moving on with their lives. So,
Don't feel like you're trapped, destitute. Because I do, and we have talked about coercive control and family violence in the past, but one thing that happens with manipulative, controlling people when you separate from them, it appears, is if they know, and we've talked about balancing the unbalanced and who's got the power and control kind of behavior. They know you're struggling financially. They know you're desperate for money and you just want to get out of this situation. They're going to lowball you with property settlement offers because you're desperate, and they're going to want to just put the thumb screws on and make you desperate enough to accept anything. And so many people, that's happened to so many people.
I've seen it. I've seen it, Laura, where they go, well, yes, in my scenario, right, my 300, yes, you can have 100,000, but that's all you're getting. You've got to sign consent orders and then we'll give it to you. So that sort of pressure is now again recognised as coercive control. But you're right. And part of the thing with coercive control, if you're coming out of a relationship where one person thinks they own everything, and then you have been brainwashed into thinking it's all their money, so you don't feel entitled to a share. It's hard for you to know to ask. I mean, it sometimes doesn't enter people's minds.
I don't think people know about it.
Yeah, I think that's right.
I didn't know.
Didn't you? Yeah.
No. And
no.
So realistically, Ma, it is a good thing to have in your back pocket to know that is something you can consider. Now, if you do have to go to court, what are the factors the court needs to consider? Do you know roughly what they're thinking about when granting this early distribution of funds?
Basically, they only need to know that it's not more than you would otherwise be getting as a property pool. So it's not more than you should be getting overall. Or if it is, that you can easily pay it back if they've given you too much. And that's really about it, I think, because why would they hold those monies away from you? It's your money. You've asked for it. Why would they withhold it from you? You used to have to show a genuine need, but you don't anymore. It's a much cleaner sort of situation now. I think the only questions the court would ask is, why aren't you offering the same amount to your ex? And that would sort of work. So I think what they're doing is trying to stop the number of interim hearings, though, because I know people don't know about it enough, Laura. The number of people I talk to where it hasn't been suggested to them by their lawyer, and they are absolutely astounded to think they can. I think it's one of the kind of first aid things that should happen. And we put it in our course, didn't we, about the spousal maintenance component. But it should be a first aid thing. So you haven't got any money, therefore you can't get legal advice, therefore you can't get spousal maintenance or any of these things. And of course, the person who owns everything in their mind usually has deep pockets, barristers, solicitors, and it's a pile on. So I wish more people knew about it. I hope our listeners remember it. And ask your lawyer. If they say no, ask them why, because I don't know your situation. But I do think people in Australia don't ask for spousal maintenance enough, and they don't ask for a distribution of property. I think the drawback of going to the courts, it's the cost. People worry about it, the cost of going to court to get money to go to court.
It's like chicken
yes.
and the egg scenario.
And so I'm not privy to what they were thinking, the government was thinking when they drafted these changes, the family violence. But I think that example tells me that they're not going to be very happy with someone who makes you go to court for a share of your money when it's sitting there. You don't even have to show what you're going to use it on. It's just sitting there. But I would, if I were making the application, I'd show that you're in need.
Well, let's talk about that. And we are not liable for any decision you make because we are not giving legal advice. We are just talking about what happens and processes in law. In Australia, Mum, what are the steps they would have to draft an application?
Yes. So first of all, you write and ask, and if you can, offer that the other person takes the same amount. If they say no, then invite them to a mediation on it. And then if that doesn't work, then you make an application to the court. You have to make a final application and then put that as your interim orders. Now, if you are in desperate straits and you need some money to be released, you don't need to do the mediation and all of that if you're broke, if you're really broke. And what you might need to do is go for an interim property settlement on an urgent basis, and the court shows you how to do that in a central practice direction. Or it may be that if they say no, then you go to court and find a lawyer who's prepared to, what they say, spec it, like not ask for payment until you get that money in your hands. So the court has mechanisms, though, for spousal maintenance, lump sum spousal maintenance or periodic spousal maintenance, so alimony. So you shouldn't, if you get someone to have a look at your situation and ask them about these two things, and that will help you take some of the dread away from it, I think.
Yeah. And look, Mum, what kind of evidence or proof do people usually put in these kind of applications for distribution of funds?
So usually they will put a bank statement or something showing the money is in an account. Probably copies of any correspondence where they've asked for a distribution and the other person has said no. If you have tried mediation and genuine steps, those like doing your proper genuine steps, you will need to file those. So probably even though it's an interim order, you'll probably have to file everything you normally have to file for a property matter, and there's a few documents there. If it's urgent, there might be a different path for you under the urgent spousal maintenance clauses.
Right.
So that's probably a bit beyond what we're talking about today.
That is.
Yeah.
And if you are interested in any of that, we've done an episode called A Response to Initiating Application. That's where we talk through every document. So you can go and listen to that episode as well if you're interested. So then, Mum, you've got, so you do that, you put it in, then what happens?
Usually the court will make an order at an early stage
so
about
that. So do you go
that.
into court?
Yes, you'll have to go into court. The first court event may not be one that you have to go into, but then if you need the money and it's sitting there, that very first court event, the registrar may send it straight up to a judge to be heard then and there.
Without you even being there?
No, you'd be there
okay.
then and there. So that's why you've got to go and be ready, willing and able to do the hearing. A judge may hear it by video link, but not really, not often. Usually the registrars who will do that.
And give me an example. So you're in there in court, standing in front of a judge, if it's been shuffled up straight up to the judge. Your ex is in one side, you're on the other side, or your ex didn't show, whatever. And you're standing there saying, I'm financially destitute. I really need to look at all this money in this bank account. Can I please have some? What does the judge usually say?
Well, you don't have to be destitute. You don't have to use all of your money up.
Your
Honour, this money is locked up in this bank account and it has been for quite some time. I would like to use it to insert something here, pay my bills, or buy a house, da-da-da. And I've requested it from the other side and they have denied me that. I'm happy for them to have the same amount of money. Your Honour, would you please make an order that money be released to me? and then they'll look at the other person and go, what have you got to say about that? And listen to them. You could, if you want to, raise the coercive control component and put a little bit of that in your affidavit, that they were always thingy about money and you weren't allowed to have autonomy.
If they gave you any text messages that said that if you leave me, I'm never going to let you have any money.
Oh, I'll see. Yep. I'll see that you're broke. Yep. We like that one.
Put that in your affidavit.
Yes. Attach it all in there. Just dob them in.
Yeah.
And then wait for the judge to do the rest pretty well. If you've got your documents done, you've attached letters maybe from the school with money you owe. If they're in arrears with child support, add that as well, because that is also a form of financial abuse. And just put the picture to the court. And mainly, you probably need to say also before that you point to your final application and say there's plenty of other money tied up in the house. This is just a little bit of it. It would be maybe 10% of my reasonable entitlement. And that will give the judge all that they need to know.
Yeah. Wow. And then if the judge goes, yep, you can have it, they'll give you an order that says you can have it. And then you walk out. And then you organise to get it.
Yes.
Feel like a sigh of relief.
So what the court will normally order is something like that the parties will do all such acts and things necessary to release the money. Now, if you've got a court order, you've signed your document to get the money out of the real estate agent's place or the frozen bank account. You need your ex to cooperate by signing that document as well. Now, if they don't, a clever thing that the judge may well put in the order is that parties will do everything they have to get that funds released. And if either party refuses or neglects or fails to do, then the registrar of the Federal Circuit Family Court can sign in their stead. So let's say the person on the other side is like, no, I'm not. Then you just take it in to the court, to the registry downstairs, and ask for the registrar to sign in place of the ex, and you probably will have to do a little bit of a story for them, a little bit of an affidavit showing how you've tried.
So look, this is all hypothetical. This
is
just a pie in the sky, but it is just so that you guys know there are ways around poopy bum things. Or why some people, it's not even that your ex may be a poopy bum. They just might think that's how it goes. No one gets any property money until property settlement happens.
Yeah.
You know?
And, business people often bargain that way. They don't give little bits at a time, otherwise they lose their bargaining power. And so sometimes they just see this as a business deal and they're going, no, not until you work out final. No, I'm not. Not until you drop child support. No, I'm not doing this until whatever.
So a question people may ask is, can superannuation be accessed early?
Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist along with the accompanying episodes of the podcast will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today.
That's a question for the superannuation fund. It's not something that the court ever orders.
Right. That's good to know. So if it's super, probably step away from the super for the moment.
I mean, look, there's self-managed super funds and you might think there was a way of getting that out. But again, they're subject to the same rules about preservation of funds as anyone else. So I don't think you'd do very well trying to get a judge to give you money out of super.
Mum, why aren't lawyers telling their clients this?
No, maybe they think it's expensive. Maybe they're trying to give the client a quick case without an interim application, maybe. It's not, it should be more common than it is. That's what I'm saying. It should be more common. But I think people need to know they can ask.
I think, and that's your same argument with spousal maintenance as well. You think it should be more common than it is. And you heard a judge say it should be more common than it is.
Yeah.
And we've done some great episodes on spousal maintenance. and a really good episode on, like I've said, unbalancing the unbalanced. So those kind of episodes will really help you if you are in that situation, and particularly, Mum, those who are separated under one roof.
Yes.
Oh, I spoke to a lady who was separated under one roof for like 5 years. They've been doing it for so long. And it's just, I think some people just can't see a way out. And I understand. I understand because you're not a lawyer. You've never done this process. Maybe you have, but maybe you haven't. But
Yep.
no one knows how this works. And so sometimes it's easier just to stay in limbo. But realistically, over time, you're going to have to go through it anyway.
Well, I think people get bamboozled by the powerful person, and they tell them what the law is, and you are so used to accepting their word that you just believe that, and they might say, look, it's all tied up. And you're going, well, hang on, but there's shares. Can't we sell shares? No, it's all tied up. It's in a term deposit. Well, you can break a term deposit. You just suffer a little bit of interest rate. So you've got to not buy into it. And everyone who's under one roof should think about, why are they under one roof? Is it that there aren't any properties to move to? That's a legitimate reason where a lot of people were under one roof. Or is it because somebody is withholding your access to your own money? That would be the thing that would get you out of the house.
So what are the risks of getting an early distribution of funds?
That's a good question. The risks are that if you ask for, say, your $100,000 and the court subsequently finds out you should have only got $80,000 overall, you may have to reimburse the other person by $20,000 for that sort of thing as an example. If you take that $100,000, again, my example, and spend all of it on legal fees, then that's on you and it comes off your share. It gets notionally added back in and then comes off your share. But if you take it and you use it for, say, a bond and some rent and food, you should document that, keep a track of that, because if you've used it for reasonable living expenses, it doesn't get added back in or taken off your share. But the risk is if you don't realise that and you don't keep a little bit of a track of what you've spent, because the court will go into it and, so what did you do with that $100,000? I can see you've paid school fees with this. I can see that there's, $50,000 unaccounted for. Well, we'll have to just say that you spent that on not reasonable living expenses. So the risk is, and it eats into your share. Sometimes when people get it, they find themselves in a massive legal case that just because you've got the money there to pay for it doesn't mean that you can afford it or that it is worth doing if it doesn't make sense to use $100,000 to pursue an extra $50,000. Do you know what I mean? So you want to still be thoughtful about it and treat it as if it's part of your property settlement and don't waste it.
Have you seen it work in a positive way to help push negotiations forward or push these stubborn, manipulative, controlling types forward?
Yeah, I have. Sometimes if one person thinks they hold all the aces because they're blocking you from getting that money, then they are less inclined to negotiate with you because they're waiting to starve you out or to give in because you haven't got lawyers. Once that money's released to you, that little bargaining chip is gone. They know you've lawyered up. Then that can start a settlement. The other thing is if you're asking for the money for yourself and you say, and the other person can have the same amount, that can soften attitudes a little bit between you both because it's a little bit of a concession. And property settlement is like this big knot, isn't it? And you start working on little bits and pieces. And sometimes that loosens the knot there. So I think, but just because you can afford lawyers doesn't mean you should go all out. I'm just saying that. And I think if the money gets released, I would think the risk of getting it straight into your lawyer's bank account would be that your lawyer then sees that as a way, like, this is our budget for the case, so we'll go and spend that budget on barristers and discovery.
Right.
So I think if you can get it given to you, if you already owe money to lawyers, when you get the money, they might need that bit paid straight to them. and they may want a little bit in trust for the next stage, but try to keep control of the money that you get.
Wow.
Hmm.
It's a big topic to think about, but it's something that you would need to explore with your lawyer.
Yeah.
And discuss it. I think, Mum, when it comes to the 4 personality types, we've got the amicable. You're probably not going to need to go to court to get a pre-distribution of funds if you say, okay, hey, I'm really struggling while we do this. Can you have an extra 20 and I'll have an extra 20 and we'll just make it fair? That's okay for amicable.
Yes,
usually?
it is. And really with amicable, the person who doesn't have access to the money or who's beginning to need the money, you're not as fearful or as stressed because you're confident and comfortable that if you mention it to your ex, they'll go, oh, of course, here. It's where the personality of the other person is going to make it hard for you that you wake up every morning with that knot in your stomach because you are broke.
Yeah.
And you don't think they're going to give you the money. So amicable, the stress is a little bit less and you normally would just agree, especially if you give them the same amount.
Can I just put in here, and I know we bang on about this a fair bit, but it's a good test for your if it is amicable. If you say, hey, I'm really struggling here. I know we've got all this money sitting in the bank. Can I just have a pre-distribution of $10,000, $20,000, whatever? We can both have some just so I'm not struggling. And your amicable ex says no, or you're too afraid to ask. It's amicable, but you're too afraid to ask.
It's not. It's if you ever say, I'm not allowed or they won't let me, these are words school children use all the time. And if you're finding yourself saying those things, then you are being held an emotional captive by somebody.
Yeah.
I'm not allowed. You're an adult. You have your own agency. You can do what you want to do.
So then it comes to avoidant, Mum.
Yeah.
If you've got an avoidant ex, how do you approach this kind of thing?
I think you'd have to do it in writing. You'd have to really say, look, oh, dear avoidant, we need some money. How about we sell the caravan? I think I'll list it with these guys, I reckon, and at this price, and then we can have half each and that'll keep us on track. What do you think about that? I'm happy to do the listing and I'm happy to do the work for that. And you can even say, if I don't hear from you, I'll assume you're okay and we'll split it 50-50. That sort of thing where you take the burden. Or in an easier scenario is, look, we've got this much money in the bank. How about you take 50 and I take 50? Here's the documents to sign. All you've got to do is just sign here and I'll take it down to the bank. They'll probably ring you.
Okay.
That sort of thing. Just smooth the path, identify the funds, even say why. Look, it's in our mortgage offset, Mr. Avoidant, but it won't hurt to take some of it out. We're in advance. It's still covered for the next 6 months. And then by then we should have property settlements. So how about we do that? That sort of thing. Make it easy for them. Do the thinking for them.
Don't do any financial decisions unless you've seen a financial advisor. This is not financial advice.
No.
But we're just talking about ways that people can approach this. So then we've got high conflict, Mum.
Yeah.
So how do you approach a pre-distribution of funds with a high conflict?
High conflict ex-spouse. Here is the definition of family violence in the Family Law Act 1975. In the spirit of that fairness.
Would not write that, Mother.
I would. I would.
Would you?
Oh, my goodness. How do you think lawyers get other lawyers to agree with them on things? You send them cases. You send them sections of the Act. I quote the section of the Act. If you start off with that, the definition includes this, and my client or I need money. There's this much money in the account. I suggest you get this much and I get the same. Let me know within 7 days. If not, I'll have to go to court and I will be making the case to the court that this has been coercive control in the form of financial abuse.
Boom.
Well, what do you think they're going to do?
Do you know, I find that bizarre that I was shocked that you would write that.
Yes.
So I can only imagine what our listeners would have thought when they're dealing with manipulative, controlling or high conflict. They're probably like, oh, I couldn't write that. So because I think a lot of people just then had their hearts in their mouths, Mum, going, what? I couldn't write that. If would be
Well,
terrifying.
I think I went into mama bear mode
Yeah.
and lawyer mode, okay? And so for mama bear mode for you guys, of course I'm going to come in all boots, all guns blazing. However, what have you got to lose? There's nothing in that letter that I just dictated that would get you in trouble with the judge. And you show it to the court and the court goes, well, he knows what a definition of family violence and he still didn't give it to you.
He or
I
she,
think
because it happens both.
I might award costs against that person for forcing you to go to court. So you have to be safe when you do this, okay? And it's really hard to stand up to someone that you haven't stood up to before. But
Holy moly.
It's weird, isn't it? The impact that it had. But yes,
So-
why not? Why not?
So I guess when we move on to the manipulative controlling, you're saying if it's safe, you can do that as well.
Why not?
Why not?
Yeah,
And if
your game's up. The game is up, mate. We know what you're doing. If she's got all the money, we know what you're doing, and you can't do this because this is what it's called. Yeah. I'm a firm believer that in our society, I know there's a lot of family violence that ends up in serious injuries to listeners, to people, but everybody knows that you can't hit your spouse anymore. We didn't know that in the 50s. When I was a kid, it was rife. I think people can learn to not hit each other, and they have. I think people can learn to not try to coercively control the other person if we constantly point out, A, that it is bad behaviour and unacceptable, and secondly, that if you continue to do it, you're going to get less property. I think it's just like educating the population. It's like littering. When I was a kid, there were parts of the roads when you drive up the east coast of Queensland that were like, they called it the Crystal Highway. Broken beer bottles, everything, all the way up the road. We had the anti-littering campaign when I was just little, and now we don't.
So you're going to name it. You just got to name it.
And you've got to name it. And it's not you naming it. You're saying, here's the definition of family violence, and here's put
what
it
I'm
there.
Asking for.
Yeah, and if that doesn't make them sit and think about it, I don't know what will. And if they've got a lawyer, the lawyer will certainly. You brought it to the lawyer's attention as well, just in case they weren't thinking about this.
So now I'm going to ask you
all right.
what you would embroider on a cushion. And I've heard you say it multiple times, and I've also heard your husband, my stepdad, say it many times as well. And I'm going to say what it is, Mum. I'm saying if you don't ask, you don't get.
Yeah.
And that is a theory you've both had for court for a long time. And you've tried to teach other lawyers this, and it's important to educate our listeners. If you don't ask, you don't get. The judge isn't going to just come up with something to help you.
They can't. You've got to give them the problem.
Yeah, so you've got to ask. And for some reason, sometimes people are too afraid to ask, or lawyers, they don't want to bother with it because it's not their usual journey. They take a path and they just do the same thing with every client. But it's up to you guys. If you don't ask, you don't get. Embroider that on a cushion. Don't tattoo it on your eyelids like that writer said. I'm going to tattoo it on my eyelid. A different saying, but
yes.
But I think that is a really big takeaway for anything when it comes to court.
Yep. And I suggest two things. One is, if a lawyer starts talking about that you've got to use up all your resources, or you haven't tried to access money some other way, they're living in the past. This is not how the law is now, and it hasn't been since Strawn. If they mention Hogan, they're out of date. It's Strawn. And the second thing is that cushion, don't leave it where the kids can see it all the time.
Yes, that's true. And when Mum says Hogan and Strawn, she's talking about family law cases.
Yep.
If you're interested in listening or learning about family law cases, we do have cases by Lynn on Patreon, where time to time she uploads her explanation of certain cases that we talk about in these podcasts. So go and have a listen to that.
You won't find Hogan there because it doesn't apply anymore.
Yep.
And I believe I've done Strawn.
I believe you have done. It was Strawn and Strawn, wasn't it?
Strawn and Strawn. Yes. I think it was Strawn and Strawn number 5. That was one heck of a row. in the
That's
court.
like
And
Mumbo number 5.
yes, and the amount distributed was in the millions
Whoa.
as an interim distribution.
Oh, there you go.
Mm.
Okay. All right. So thank you, Mum, for your time. Anyone who's listening today who is financially stressed and out of their brain, go to listen to our other episodes. Go and talk to your lawyer. Realize there are other options, and you got this. Thanks, Mum, and we'll see you guys next week.
No worries, Laura. Bye. Keep
Bye.
safe, everyone.
Bye-bye.
Bye.
If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording